Well, I will just say, I'm afraid I do have to say a few things about this private international law business, and I have 2 slides on that. The reason for that is that it is very important for anyone doing business with anyone else in the world, whether it's UK companies doing business with Belgian companies or anyone else, is that it's not because you do business with Belgium or indeed in Belgium that you are necessarily subject to the jurisdiction of Belgian courts, and certainly that you are necessarily subject to Belgian law. And I will get to Belgian law in a second. There are effectively 3 parts to this international business chain of events, if you like, which are collectively known as private international law. The first one is jurisdiction. The second one is applicable law. The third one is recognition and enforcement. So jurisdiction basically is the question, when I do business with other parts of the world, the same applies, nota bene, to one's private life, right? If I marry someone who's not in my country, etc., then the question is, well, what courts will hear any disputes between us, if there is any dispute, and indeed, what law will they be applying? One or two of you may have heard echoes of an unwelcome development in that respect, which is that clearly following Brexit, the UK no longer applies some of those core rules on jurisdiction. That's collectively known as the Brussels regime, as you see here on bullet point 3 of slide 3. They're no longer applying those European rules. There was a request, or there is a request outstanding of the United Kingdom to join an outfit known as the Lugano Convention. And the Lugano Convention basically does very much the same as what EU law did beforehand, which is to agree rules on courts that will hear a case if there is a dispute. And to then also, and that's an important element of this, to near automatically recognize each other's judgments when there is a judgment in a litigation between commercial parties or indeed between private parties. That last element, of course, is very important as well. I mean, it's all very well to have a wonderful judgment from a court in Ruritania, which is a non-existent country that's just used by way of example. From a court in Ruritania, a gorgeous judgment, which tells you that you're absolutely right and you should be given £100 million by your former business partner. If you then can't enforce that judgment, then frankly, you haven't achieved anything. So the element of recognition and enforcement is very important. This Lugano Convention achieves a similar result as EU law in a broader community of states, namely some states that belong to the European Free Trade Association, Iceland, Switzerland, and Norway, also Liechtenstein to some degree. The United Kingdom wants to be part of this, and so far the European Union have resisted their approval to this request, and the EU, as it happens, do need to agree to this. So that's an unfortunate development. We'll have to wait and see how that will play out in the future. In the meantime, I think it's important for you to know that when you do business with Belgian corporations, one of the safest bets to ensure a recognized jurisdiction and also therefore an enforceable judgment is to go via choice of court, exclusive choice of court. So this is where you agree with your business partner, if ever there is a problem between us, then we agree that we will make it subject to the exclusive jurisdiction of the most obvious case, the courts of England and Wales, or indeed a court in the EU. What's important as well, and this is the final bullet point on this slide, is that regardless of what you agree with your business partners, etc., those of you who reach out to private consumers, so B2C contracts, for instance, by using web shops, etc., will be subject to the jurisdiction of EU court, regardless of what you agree with that customer. So if I buy a suit from I don't know, Toast or something in the UK, I don't think they run suits. Anyway, if I buy a suit from Toast and I agree that my contract will be subject to the jurisdiction of English courts, then a court in the European Union will simply disregard this and will accept that I should be able to sue Toast in the European Union. The same is true if you were to employ people in the European Union. Those employees will always be able to sue you, regardless of what they've agreed with you, in the member state where they are actually employed. On my sheet, I am now on slide 4. I hope that's the same for you on the screen, where I say a few similar words on applicable law. And this is the point why I mentioned Belgium between brackets. It's not because you do business with a Belgian corporation that you necessarily have to choose for English law to apply. Again, for consumers and for employees, the same, by the way, for insurance contracts, that will probably be the case. You will be subject to European laws. But if it's a straightforward B2B contract, then you can choose what law will apply. And that also goes indeed for English law. So it's perfectly possible for these contracts to be subject to English law, and that choice will be respected by courts in Belgium. Indeed, that will be respected by courts across the EU. That's quite important. You can still choose for English law to apply as much as you could choose, in fact, for, say, the laws of New York to apply to your contract. Clearly, there are some limitations to this. I won't go into that, but there is, of course, a certain margin within which those courts in the EU will still apply certain very strong rules that they feel strong about, like as you see on the bullet point here, privacy laws, and indeed to some degree also agency contracts. Recognition and enforcement we've talked about already. I now move to the slides which say a few words on that sort of basic nature of Belgian law. You heard, first of all, the chair introducing in the previous session, the collective session, you heard him talk about the various regions in the EU, in Belgium. It's clear, of course, that when it comes to public law, those laws, of course, will differ greatly across the various regions. That does not include corporate tax law. So tax law, of course, corporate tax law is subject to Belgian rules, federal rules, but an awful lot of taxation in the area, for instance, of environment or in the area of land law, etc., will be subject to regional rules. And therefore, those, of course, will differ depending on which part of the country you do business with. On the general issue of, then, let's say, Belgian private law, it is generally said that Belgium, like many of the European countries, has a system of civil law as opposed to the English and Welsh, and also to some degree Scots notion of common law, but that must not be overestimated. Many of us have this kind of often romantic notion of the common law being a system whereby a judge, in a sort of assessment of what she or he thinks is the best or the most appropriate in a case, will somehow pluck law out of some thin air and then apply it to the case at issue in a very relaxed and flexible way. And that on the opposite side, in a civil law system, the judge will just simply apply like a robot whatever statute tells them that they need to apply. Clearly, neither is the case in either system. It's very clear that in the English law, an awful lot of law is statutory law, and it's conversely also true that in civil law countries, an awful lot of the law that applies is actually subject to case law, is subject to what the courts have decided, and then therefore also, and this is a point of attention, depending on which court you might end up with, is also subject to different interpretations. And there, of course, Belgian law does lack a sort of more formal rule of precedent, whereby the courts are bound by the jurisdiction of the higher courts. There is a de facto rule of precedent if a case is taken to the Supreme Court, but in many ways, lower courts have quite a lot of wiggle room in giving their own interpretation on these issues. And again, that means that, for instance, in your choice of court, it's sometimes important to make sure that if you do choose for a Belgian court, that you end up in a jurisdiction in a specific court that in your area of business has a more attractive interpretation of those laws for you. So there is an important element to, and I'm coming now to what I think is my last slide, an important element to Belgian law, indeed, again, to many civil law countries, which is this notion of good faith in applying contracts. And there's a very current example of this, which is the AstraZeneca litigation, which I'm sure has not escaped you. The European Commission, on behalf of the member states, taking AstraZeneca to court for the alleged failure to supply COVID vaccines to the European Union. That contract is subject to Belgian law. And the result of that is that a Belgian judge who's currently looking at that litigation will apply, of course, what is being written in the contract, but will, over and above what is written in the contract, will interpret that contract in what she or he considers to be the good faith of the party. So they look beyond the mere writing of the contract into the contractual intention of the parties and the good faith with which those parties abide by those rules. That is very different. That's dramatically different from what an English judge would do. It's one of the attractions of the English law, English contract law, is that the judge will simply apply what has been agreed and nothing less, but neither certainly anything more. That's quite an important difference between these various issues. An important distinction also between civil law, contract law, and common law, contract law, is this idea of consideration. Many of you will know that as the notion of a peppercorn rent, the fact that for there to be a valid rental agreement, there needs to be some kind of rent, even if it's just a tiny peppercorn. There's an interesting fragment here of Better Call Saul, and I've linked it to the site so you can look it up tonight if you like, where you can see this at work. I won't give away any spoilers, so just look at the little clip there in Better Call Saul. But it's very important to appreciate that whilst under common law, both parties need to agree, need to put something into the agreement, famously by President Trump, recalled as being the quid pro quo element of a contract. In civil law, contract law, you can actually have a unilateral contract, which of course in English common law is a complete oxymoron. In civil contract law, that does actually exist. You can have a unilateral contract. Also importantly, in many civil law systems, an offer and an acceptance mean that the contractual knot is tied. So if someone sends you an offer and you accept it, then you have a contract and you have it in the terms that were suggested by the person making the offer. That too is a notion that is largely alien to many parts of the common law. Finally, an important distinction between specifically Belgian law and English law, but not just English law, between Belgian law and many other states in the EU as well, is that Belgium has a very strong feeling about the protection of the agent. So when an agency contract is being terminated, Belgian courts will always apply a very strict protective regime should the case end up before their courts. And that's the case, by the way, for many so-called gold-plated EU issues. So gold-plated law means that a member state implements a European directive, but goes further than what the directive requires. That too is, of course, something that one must be very aware of. And I'm afraid that the only way in which one is aware of those issues is by consulting a lawyer. That brings me to, in fact, what is my last slide, which is the issue of the role of lawyers. The Belgian legal profession is large, right? There's many lawyers, practicing lawyers. We no longer have the distinction between barristers and solicitors, although in practice we kind of do, because some of us do specialize in litigation whilst others don't. But there's certainly an important difference between the commercial intuition of some lawyers against those of others. Not all Belgian lawyers will intuitively precede a client or approach a client with the idea of solving their problems. Many feel that their first and foremost responsibility is to point out the issues and to point out potential liabilities. There are many lawyers that do think about solutions with the client, but of course, it's important to realize whether you are across a lawyer who is in that state of mind, as opposed to a lawyer who, in order to cover liabilities of the client and of themselves, tend to be perhaps a bit more conservative. Therefore, if you team up with a local counsel, I think it's going to be very clear that they will be able to tell you which, in the area of specific expertise, would be lawyers that might be thinking with you rather than just thinking about the problems. I'm afraid I spoke much longer than the 10 minutes that I was allocated, but I did try and keep it short, and I hope I managed to bring some core issues, at least, or some sort of messages across. Thank you.